all of you. I must thank BW to have all of us here. It indeed is a real pleasure to be here with my esteemed panelists, and I would just take 1 minute each to introduce everyone here. Mr. Pramod Dubey actually needs no introduction. He's a well-known, well-regarded face as a senior advocate in the Delhi High Court and Supreme Court, and has actively contributed a fair bit to the jurisprudence when it comes to especially bail law. We have Mr. Siddharth Batra here with us, who has been standing AAG for Additional Advocate General for the state of Haryana, a well-known AOR in the Supreme Court. We have Samudra Sarangi here, who is a partner with law offices of Panag and Babu, and constantly is advising various companies which are on the Fortune 500 list and Nifty 500 companies on white-collar crime issues. Nikhil Varshney here is a director with Cyril Amarchand Mangaldas, and is also a well-known face when it comes to advisory relating to white-collar crimes and money laundering. The topic for this panel is rather interesting because it is, bail law actually is today in the country a much talked about topic. The media covers it enough. When we go back in history to the 1950s as well, since then Supreme Court has repeatedly held that bail is the rule and jail is an exception. But the trajectory of the bail jurisprudence has seen a lot of upheaval, especially since the advent of white-collar crime in India has been on the rise with the 2G scam and then the coal scam. For the first time when, despite the Delhi High Court judgment, where accused in 2G scam after filing of charge sheet were taken into custody, that led to the Supreme Court's judgment in Sanjay Chandra, once again reiterating the principles on bail. But since then, again, we've had a lot of upheaval, especially with the twin conditions in the PMLA Act and the serious fraud investigating office powers. So on that note, I think I will leave it to my panel to take it from there. I will start, of course, with Mr. Dubey. So my question to you is the bail jurisprudence in India, especially when it comes to white-collar crime cases, in consonance with Article 21 rights provided for in the Indian Constitution?
You are well versed with, because you are practicing in the criminal side. One thing is very important in the entire criminal jurisprudence. That is the presumption of innocence.
Correct.
So during the course of the investigation of the trial, you are not held guilty. So you being the person, you have the very precious right, that is the Article 21. And if you go in the entire structure of the criminal jurisprudence, the entire structure of the criminal jurisprudence is based on Article 21. From the very beginning till the end, the accused persons are being given the right every time to prove their innocence. Like at the time of the investigation, you have the right to move the application for the bail. After the filing the charge sheet, you can move the application for bail. Then the supply of the document without making the payment to the, then it is a duty of the court to supply you. You can consult your lawyer. If you are not able to engage the lawyer, the legal aid and the court will provide you the amicus curiae to assist you. Even at the last stage, every accused would make the statement on oath, but the accused has been given the right to make the statement without oath after consulting the lawyer. So the entire things, if you see the chronology of the entire criminal jurisprudence, the only thing you will find Article 21. And one thing is very important, and we must understand the only test in the entire criminal jurisprudence, whenever you are fighting the case, every stage you will find the doctrine of prejudice. This is very important. If the state is moving an application or the accused person defense is moving the application, the only test before the court is what prejudice is being going to cause. And you have to meet out your case regarding the prejudice. But there is no thermometer, there is no measurement of your prejudice. You cannot measure this is my prejudice is 60 centimeter or 90 centimeter or 99 centimeter. So there is only thermometer and there only test to examine your prejudice is Article 21. You cannot deprive the personal liberty of any individual without except the procedure established by law. So you have to follow the procedure established by law. And that's why we have Indian Evidence Act, we have the criminal law, we have the special statute. The moment there is a diversion from the procedure established by law, the benefit would always be given to the accused, not to the state. It is the duty of the state to follow the procedure established by law. Because the entire criminal jurisprudence, the concept is the right and duty. If you go to the basic concept of the Hoffeldian scheme of the jurisprudence, it is the right of the, if there is the right of the accused, it's the duty of the state to protect the right.
Absolutely, sir. Agree with you.
So I would say that Article 21 is the jewel of the criminal jurisprudence.
Absolutely, sir. Thank you for that, sir. My next question is to Nikhil here. Nikhil, since you are more from the industry specifically, I wanted to ask you, do you think that the reluctance or the alleged reluctance in granting of bail is dampening the entrepreneurial spirit in the country?
I mean, Neha, I don't think anybody sitting in this room would deny the question that you have asked. I think it's it's very much known that the environment in the country, at least in the white collar crime space, is such that whenever an investor comes into India, it's not, while of course a lot of focus has been on ease of doing business, but this is also one of the areas that an investor looks into, that how are the courts coming to rescue, just in case the company or they are in legal trouble. That's one part of it. The second part, of course, is we saw recently Justice Diva Chandrachud announcing 10 bail cases every day being heard. While of course the intent was correct with respect to hearing the bail applications. But I think what got left out is the white collar crime sector. Correct. Because at least in while there are certain judgments which recently came in after NTL came in, NTL 3, be it Justice Bambani's judgment in Ashish Malhotra, or maybe Rana Kapoor, wherein the court, at least the Delhi High Court, if not the other high courts, have started giving green signal to bails, be it in ED matters or be it in PED matters or be it in the SFIO matters. But yeah, I mean, any investor coming into India would definitely has a question if the courts in India would come to save them. And funnily enough, the problem is that when the business is hunky-dory, everything is all good. But once you are in a soup, then you crumble like anything.
So that lawyers also are remembered, no?
Yeah, yeah. And I think to some extent, maybe the IBC also has some role to play there, because it is only after the IBC came in that we saw, and of course it all started from 2011 when Sanjay Chandra came in. But we saw, and it merged with the enactment of IBC that, once there's someone going insolvent or maybe fraud circular, fraud, a bank account turning fraudulent, it's all the enforcement agencies start getting active about it. So that way it is.
So you're actually right to say that, and that in very many cases, IBC and ED issues or SFIO issues go hand in hand. One triggers the other. So actually, that leads me to my next question to Samudra. Samudra, tell me, how relevant or important, or more appropriately put, necessary is it to arrest somebody in sort of any money laundering issue or a fraudulent bank account issue triggered by the declaration of account as a fraud, especially when most of these transactions go back to the hunky-dory period and all of them are documented. So it's not that you need any recovery to be made. How relevant is an arrest in such cases?
Yeah. So I think as defense counsel dealing with white collar crime issues, we have a lot to bemoan in terms of how jurisprudence has evolved in terms of white collar crime. But the one thing that I think the agencies have a right to bemoan even more is the task that they're faced. Correct. It's a complex job. It's not, investigating somebody through and through to either identify somebody who's guilty or if actually a bribery crime has been committed. And when it comes to money laundering, the threshold is even higher, right? So given the significance of the task, unpopular opinion or not, I believe given how structured some of these crimes can be. Arrest is probably one of the more effective ways to investigate. Now, I say this with a little bit of pinched conscience and some assumptions, of course, that if an agency is doing its job without any sort of influence and it's really conducting an investigation independently, subjecting yourself to arrest and walking out on the other side, explaining to them your innocence is probably one of the best clean chits you can get, even better than getting a clean chit from court. So I feel arrest is an important tool that agencies have to exercise. The question really becomes is it being exercised to find the truth or what the facts are regarding an investigation, or is it only being done to deprive liberty? I think one set of exercise of power, moral, has a higher ground to achieve maybe some tangible benefit to the investigation at large. But if it's being exercised to curtail liberty, which in some cases more often than not is what seems to be becoming the trend, I think that's a dangerous set of jurisprudence that we're sort of walking into the future.
I'd like to follow that up actually with a short question to you. How do you read what you just said with the Supreme Court judgment in Until, where Supreme Court has categorically said that if consciously somebody is not arrested, and then post-filing of charge sheet, you needn't arrest them. How do you read it in with what you're saying? That means the investigative agencies actually have the power not to arrest, also have the discretion not to arrest, especially in white-collar crime cases.
Yeah, so I think one important trend to observe is there's no longer a case where there's only single charge sheet, right?
Yeah.
There are cases with multiple charge sheets, cases with 7, 10 charge sheets.
Correct.
The more complex ones. So there is a scenario where a charge sheet has been filed and you still need to investigate further to unearth everything else you're discovering as part of a supplementary investigation. Now again, as long as the supplementary charge sheets, the supplementary investigation is a follow-up to the initial investigation, fair enough. I think there's a merit to be had in a post-charge sheet arrest as well. But if the objective again is to come back with more dirt only to stick somebody in jail for an extended period of time, that's complex history. I think investigative agencies' motivations play a large part in whether that's a fair practice or not.
I would tend to agree with that. Siddharth, I'd like to ask you, tell me, in your view, is it correct to classify economic crimes as a separate category of offenses, especially when it comes to bail?
Good evening. First of all, it's great to be sitting next to Mr. Dubey, I believe, an authority when it comes to white-collar crimes. I've had the pleasure of assisting him on a lot of matters, and great to be with him on this panel. And thank you, Hina. I got to know you a lot of in-depth knowledge about this as well. Though this doesn't remain my area of practice, but I've also seen, since as a practicing lawyer, as to what has happened. I've had the opportunity of advising a few clients on this. Obviously, look, as far as...
Slightly closer.
So now, lately, if you see, the PMLA is what we are talking about, as what was mentioned about Vijay Madan Lal, the judgment. One of my fellow panelists was mentioning about. Look, the PMLA is, as an economic offence is associated, one, with the schedule offence. It has to be a schedule offence first, which is provided in the list in the PMLA, and then comes the PMLA. This becomes a very significant feature because it becomes, first, it's an economic offence. It's to do with the social system that we have, and it's to do with the economy of the country as well. So therefore, to categorize it separately, I believe Neeha is completely valid. There's no problem as far as the categorization is concerned. Obviously, as you see that what is lately happening is that bail has become very difficult to get in cases of PMLA. Usually, the twin conditions which are coming in Section 45 is a very hard thing to cross. And the law is completely different, as you were also mentioning initially, that in fact it has to be shown by the accused as to how he is not guilty. And if you see that reading of the section itself, it says that the court will only grant you bail when it is shown on the record that the person is not guilty of the offence. Though Mr. Dubey can put more light into it, what my reading is that ultimately it's equivalent to an acquittal. It's today.
It's one of my follow-up questions. And
yes, it's that severe, if you ask me. And the second thing is that the question that you've posed to me about this being an economic offence, look, it is connected to a scheduled offence, as what I said. If there's an offence under the IPC or the Prevention of Corruption Act, it does not originate on its own. Whether a person can be kept inside or whether a person can be prosecuted under the PMLA alone is a question which has been answered by Vijay Madan Lal, but If you ask me, the Enforcement Directorate is interpreting it differently, and in some cases the ED is saying that in fact the accused need not to be in the scheduled offence if he's actually laundering the money which has come out of their offence, and it's single on its own can stand as well. Vijay Madan Lal, yes, put some clarity on it. What we as Defence Counsel read it as that, look, it can't be a standout offence on its own. It has to be connected. But yeah, obviously, as far as the categorization is concerned, it's a serious offence, and since it pertains to that way the economy of the country, I believe I consider the categorization to be completely, perfectly valid.
So, Ms. Dubey, I'd like to ask you, sir, you know, there has always been this whole debate about bail is the law, bail is the rule and jail is the exception. But somewhere post 2011, the Sanjay Chandra judgment, Supreme Court started taking a divergent view when it came to economic offences by broadly saying that by Jagan Reddy and Neera Yadav, that economic offences damage the social fibre in the economy of the country, and hence bail ought not to be granted, it should be restrained in such conditions. That coupled with what we call as the twin conditions, more particularly in the NDPS Act, PMLA, and now SFIO, which is where one, the public prosecutor has to be heard, and two, you have to give, the court has to come to a finding, which is pretty much equivalent to an acquittal, that there is no offence as alleged made out. So the bailing arena, if I may call it, in the country is stormy and tough. There have been divergent views, even with the twin conditions, where in 2017 Supreme Court struck down the twin conditions in Section 45 of the PMLA, Nikesh Tarachan Jain. Then Parliament, by an amendment in the form of a clarification in August 2019, resurrected it. That came to be challenged in Vijay Mandal Lal Chaudhary. Finally, in Vijay Mandal Lal Chaudhary in July 2022, it was upheld. Now, though of course the twin conditions when it comes to SFIO is still pending consideration, the fate of it is almost fait accompli. My question to you really, sir, is we've also seen until happen, three rounds of until 1, until 2, until 3, which is now also the last one made it applicable, the principles of until, as referred to earlier, to anticipatory bail law. But sir, my question is, and it's a disturbing question as a defense counsel, that are these twin conditions absolutely relevant? Are they required? Do we need them to be on the statute book? I mean, in your view, are they not, if they're not applicable to the predicate offence, why have them in the offence that arises out of the predicate offence?
Neeha, being the part of the judicial system, we have the judgment in the Madan Bijay Lal Chaudhary.
Yes.
And Madan Bijay Lal Chaudhary has already given the finding that twin condition is constitutional, not the unconstitutional. You have rightly mentioned that the Nikesh Tarachan, it has already been declared by the Supreme Court that twin condition is unconstitutional. But see the beauty of this Madan Lal Chaudhary's judgment. Even after Madan Lal Chaudhary's judgment, Justice Rivington, who was the author in the Nikesh Tarachan, has openly made the statement at the public forum that this judgment, Bijay Lal Chaudhary's judgment, is not in consonance with the personal liberty and the constitutional mandate of the country. So even there is so many views are there. See, ultimately the question is bail. What is bail? Bail is for the limited purpose to ensure the person's presence to face the trial. You cannot put the stringent condition by putting the draconian law, depriving the person. You cannot judge the person, whether he, and how the accused, this is also debatable, how the accused will prove his innocence at the stage of the investigation when the entire materials are lying with the prosecuting agency. And how the court will give the finding he is not guilty and he will not commit any offense in the future. So this concept of the twin condition is completely stranger to the concept of the personal liberty. But we don't have any option. The Supreme Court has already given the finding. But the beauty, we are very lucky, we are practicing in the High Court and we have the judgment of Justice V.K. Jain of Delhi High Court in Rana Kapoor. If the person has not been arrested and the complaint has been filed, at least we have the one set of the judgment which says that no, there is no need to put the person behind the bar. The question we have put the Y. Jagan Reddy case, yes, there was a juris at that time ki the economic offences and it should be seriously be taken and it is damaging the social fabrics and everything. But we are again very fortunate, we have got the jurisprudence by Justice Sanjay Kishan Kaul in Satyendra Kumar until, and he has clarified even the offences are of economic offences. This cannot be the sole ground to reject the bail. You have to see the entire material, you have to take the holistic view, you have to consider the bail jurisprudence. So as on date, because Satyendra Kumar until started with the 2 judges, ultimately it went to the 3 judges. So at least we have the judgment of the 3 judges which says, ki no, why Jagan Reddy case is not the sole test for the economic offences, and the judges have the discretion to grant the bail. And I think since I am practicing in the defense side, so most of time I have taken the opportunity to defend the right of the accused and follow the personal liberty. So in my view, there is no purpose for the continuation of the twin condition and put the person behind the bar as a pre-trial convict. They are not the convict, they are the pre-trial prisoner. And that time, unless and until you release the person, how the person will create the defense? How will assist the system? So you are depriving the person by putting this in a stringent condition only under the garb of the so-called commission of the offence of the PMLA, SFIO, though there is no twin condition in the schedule offences. So they are bail on the schedule offences, but you are putting person behind the bar for the money laundering. And still, till the court has to come to the conclusion whether there is a commission of the offence or not. But you want to test everything at the stage of the bail. So I don't think that putting the twin condition is in the spirit of the protection of the personal liberty of a human being.
Thank you, sir. I think that's a great deal of insight into the position of law. Samudra, my next question is to you. In your view, since you are a defense counsel, like most of us here, in your view, does delving into allegations and requiring the court to come to findings on the alleged role of the accused in the offense, does it result in conducting a mini trial at the stage of bail?
There's a short answer to that, yes, it does. There's a lot of jurisprudence now that we keep saying that, you shouldn't have mini trial at the stage of bail, but I think that's more paperwork as opposed to what we see in trial courts and what we have to fight in the High Court.
I know it was a rhetorical question to ask you.
Fair, but this is how I look at it though. I think I echo what Mr. Dubey said wholeheartedly, right? And at a principle level, I don't have to say much more about what I feel about the twin conditions after what Mr. Dubey said, so that's taken care of. But since the Supreme Court sort of closed the door on what twin conditions may look like in the future, it's pretty much going to be this. As defense counsel, our role has changed. I think we can no longer rely on the standard tests of bail that we've been historically relying upon for the last couple of decades.
A triple test.
A triple test is no longer, I think everybody here has defended somebody where we filed judgment compilations with until 1, 2, 3 and all the judgments that are, but other than adding to the wealth of paperwork for the court's disposal, they don't seem to move the needle on bail. So what I feel we really need to do is change what our approach to dealing with money laundering cases especially. I think we have to be open that we have to fight an ECIR like it was a charge sheet. And then when we get a charge sheet, you fight the charge sheet like your life depended on it, like you were fighting a conviction.
Correct.
That's the only way to get bail. I feel
it's a very interesting prerogative, actually, perspective.
I think we are past the stage where we can fight the twin conditions. I think that fight was fought and that's been lost. So I think we have a moral duty now to fight the twin conditions for what it is and an ethical duty to our clients to find a way around it.
Correct. I take this to Nikhil. Nikhil, very correctly you mentioned the Ashish Mittal judgment, which recently by the Delhi High Court, Justice Bambani said that, even at the stage of bail, you need to prima facie come to a finding. So basically he's kind of, blown off the steam to some extent. But despite that, I'll ask you, do you think twin conditions actually prejudice the accused of a defense? Because even prior to, arguing charges, you are going down, arguing your entire case. Do you think that causes a fair bit of prejudice?
That indeed does. No two doubts about it. That, the twin condition basically is more like a test other than the regular conditions that are there for a bail. you have to undergo the test of the twin conditions which are there,
Literally, it's a
and
five
which again, as
conditions.
Dubey sir had put it, that it's more like you are undergoing a mini trial, and this you also just said it, that you are undergoing a mini trial at the time of bail, be it for the regular bail or whatever the case is. But having said so, I would also like to say, again, hats off to the Delhi High Court and hats off to Justice Bambani, that at least in Ashish Malhotra, he says that don't see these two conditions. These are only the conditions that have to be, the test that has to be passed through. But don't see them as, as anything which is benting against the accused. Whatever evidence you may have, howsoever good the prosecution case may be, at the end of the day, it has to pass through the test of, the trial.
Correct.
So that way it is. That's how I see it.
Thank you for that. And before I think we're running out of a lot of time, and I have my closing comments also. So, Siddharth, I'll quickly ask you this. So, there is an exception to the twin conditions, which is basically it's not applicable to the sick and infirm, to women. Being the only woman on the panel here, I should not be saying that. But, to women and to anybody who's under the age of 16. So, in your view, are such exceptions required, or do they create prejudice?
I think we all will agree here on this dice that that's the silver lining. Since being the twin conditions as discussed by the earlier panelists, it's so hard to get the bail. So that's the only silver lining that we have, that in fact on medical conditions and all that, bail is being managed and courts are granting bails. But as far as your question is concerned, that as to whether these exceptions are in the right spirit or not, obviously yes, I feel women have special needs, and ultimately, my personal opinion, that in some cases women are the directors, but it's the men who are running the business. And if there are some cases of the PMLA and with such stringent conditions that they have, it may not be the right proper thing to put the woman behind the bars. And the incarceration is also long. We are seeing that usually in cases of PMLA, it's very hard to get bail, not before the final complaint is filed, but even after that, it's very difficult to get the bail. And number two, regarding minors who are less than the age of 16, obviously we already have a law.
Yeah.
They are considered to be
The
juveniles, and there is a reformative theory that our jurisprudence follows. So on that, I believe it's in the right context. And other disabled, and I think the care has been taken, because ultimately it's a fraud which has been played upon in the PMLA, where some money has been laundered, and where some people with special needs may not face the incarceration. So exceptions have been drawn, I think rightly drawn, and I think a lot of us are now trying to manage for our clients if they can get out on some medical grounds.
Yeah. Thank you for that, Siddharth, and I'll finally take it to the closing comments. What I have personally noticed as a practitioner of on the white-collar crime side is that multiple bail petitions sort of end up clogging the courts. So trials don't really end up starting. And then there is this whole hue and cry of pendency of criminal trials or trials generally, but read that in with this unnecessary load that comes in with bail applications. And because there are multiple accused now, multiple bail applications. So, Mr. Dubey, I'd like your views on that.
See, Neeha, my first concept in the criminal law is bail must be granted. There is no purpose keeping the person behind me. And one interesting thing I would like to mention, you have mentioned regarding the exception regarding the women, I would like to say, you won't find, since the enactment of PMLA Act till date, any female, any woman has fled from the justice who are facing the offences of PMLA or the SFIU. So one thing, second,
law-abiding by nature.
So, yeah, that's a law-abiding by nature. So they have not read, they have not misused the personal liberty granted to them. And the courts should see, one side we are crying, every forum, our judicial officers, the Chief Justice, everyone has the concern of the pendency of the matters. What we are doing, we are multiplying the pendency by denying the person behind the bar. Every time they are, after a month, after 2 months, the first bail application, second bail application, third bail application, because the person is not willing to stay in the jail. They have the right, they are the human being, you cannot put behind the bar on the assumption and presumption of your investigating officer. So at least you should be liberal. And I'm also again saying that we are very grateful to the jurisprudence led by Justice Sanjay Kishan Kaul in Satyendra Kumar Antil. And the Satyendra Kumar Antil has opened the path. And not only that, in Satyendra Kumar Antil there was a defiance of the order passed by the Supreme Court. And the Justice Sanjay Kishan Kaul passed the direction to send the judicial officer for the training. So this kind of the proactive approach should be taken by the higher judicial officer so that the lower judicial officer should be encouraged to grant the bail.
Yes.
Unfortunately, what is happening, if you are getting the bail from the lower judiciary or the trial court, there is a presumption that no, there is no application of why the bail was granted immediately. You see latest what happened in the Priti Chandra's matter.
Correct. It's unfortunate, sir. It's unfortunate.
She got the bail after being behind bar for more than 2 years, and then they immediately stay of the bail. So this kind of the thing will increase the volume
Yes.
of the matters in the Supreme Court and the High Court and any matters, and there would be, there is a 100% certainty
I would
for
like
the
to
multiplying the pendency
interrupt.
of the matter you cannot reduce.
So on that note, I'd like to interrupt because you have a paucity of time and ask Samudra and Nikhil and Siddharth for their short closing comments, please.
To close, I'd say that the rules of the game have changed, and I think we need to change with it. To borrow from one of India's historical oppressors, if the ED or the agencies fight in the sun, then we fight in the shade. If they fight in the rain, we fight in the dry. But the question is, the fight's on. But one thing I'd like to borrow is, lower courts do need to come in. Lower courts do need to start granting bail a little more. That kind of jurisprudence has to flow down from top down.
Correct.
And that's
think
when we'll see historical change.
Our Chief Justice has been very clear about that in
And
recent
I hope
times.
that continues.
Absolutely. Nikhil, I'd like your views.
So I would say that we have until now we have seen until 3. Now let there be until 4 and until 5 possibly, because of course the Supreme Court is monitoring all of the entire case. And now until 4 should be like this, that let there be consolidation of bail applications when an investigation is happening, when 2-3 different enforcement agencies are investigating one particular transaction or one particular accused. So let there be consolidation. Let one particular judge hear the matter, dispose of all the bail applications arising out of different enforcement agencies in one go. In the event it is so happening that the second bail is to be filed because only the investigation came into picture only when the bail was granted in the first matter. This investigation by ED, for example, began only subsequently, then in that case, the first order of bail should act as an aid, as a protective order for me, so that I don't go running behind, taking that again anticipatory bail or something.
And on that note, I take it to Siddharth for his closing comments.
Yeah, I'll be quick. I think I can feel the pain of all the lawyers at the dice that bail has been very, very difficult. I think the law needs a relook as far as twin conditions are concerned, and you talked about, Neeha, rightly about the pendency of the case and time it's taking. Look, what the investigating agencies are doing, they're coming up with a plethora of documents in order to completely implicate somebody in an offense, and you're not even getting the bail. I know it's completely taking a lot of time. I echo what Mr. Dubey said about what Justice Rohinton later on made a comment on a public forum about the judgment. I think I completely agree that this needs a complete relook, and the lower judiciary needs to be sanitized as well, and their orders, when they grant bails in such cases, should not be looked upon with such kind of suspicion. And it's not just the superior courts which have the right to grant bail. I think our lower courts should have those powers. They already have the powers, but they should not be looked with any kind of suspicion. Yeah,
thank you, Siddharth, for that. I'd obviously like to thank my esteemed panel for their views. It's been a very thought-provoking session. It's been an absolute...
And one thing, you'll give the credit to all the panelists. We are very disciplined panelists. We have basically made up the time.
I absolutely enjoyed
So credit goes to the jury chair and the moderator.
No, sir, it's so much so for diversity. I'm the only woman here. I have thoroughly enjoyed moderating this panel, or should I say manning this panel. But on that note, thank you once again. And I may open the house for some questions.
I have a question for Mr. Dubey. You talked about bail is a must, right? We also talked about the situations where trial court doesn't grant the bail. What happens when the FIR is quashed? What happens when the accused is discharged after the filing of the charge sheet? Why is that jurisprudence not developing where the state is compulsorily made to compensate for the wrong jail? The accused has been put into the jail. Why is the police officers or the investigators not penalized because they have made a wrong arrest? And we all know two things for sure, which is a matter of something which is in public domain. Many a times these arrests are motivated. Many a times the FIRs are filed, which are motivated FIRs. So why is that not happening? So tell us something about that.
Thank you, Mr. Sundaram. I would like to say that we as society are not proactive. There is a provision for the malicious prosecution. If you go in the CRPC, there is a provision, I think 188 or 182 CRPC, IPC, which give the, there is a provision. If somebody has done the malicious prosecution, you can file the case. Even there is a provision, you can file the suit for the declaration and the compensation. But the people are so apprehensive, they don't want to come forward and file the case against the state agency because they are always carrying the apprehension that they will be implicated in some other case. So everyone enjoys the peaceful life and they are basically forgetting what is happening. We are not in that country where we are so proactive, we are so pressurized, so apprehensive with the state machinery. That's why we are sleeping over our right. But we have the provision.
No, but I'm on the point that why is the court not making it a part of the order by which they are quashing the FIR?
See, there are two things the questioning. One is the ingredients of the cases are not made out. Second thing, the factual aspect. Third thing, if there is acquittal, ultimately there is acquittal. The prosecution failed to prove this case beyond the reasonable doubt. And there is one finding that there is no material at all. So it totally depends upon the finding of the court. If there is no material at all, then you have the right. You have the right to prosecute the person who has initiated the malicious prosecution. But if there is, your acquittal is based, your questioning petition is based on the technical ground, of course, you are not liable to be compensated. So there are so many things in the criminal jurisprudence to get the FIR quest. If you apply Bhajan Lal test, then this is all together. And this is also the one of the ground for the Bhajan Lal is the malicious prosecution, then it is the liable to be quest. So we have the provision, but the only the thing is the people are not coming forward, they are not utilizing their right. So it is not like that there is no provision. And why the courts should be so proactive? Because we have the three-tier judicial system. If suppose the trial court has given the finding, you never know what would be the finding in the high court. And the litigants, the accused persons have always apprehension. If they are going to file the case for the compensation, the state will fight tooth and nail to get the order set aside, then they will go behind the bar. So nobody is trying to and willing to fight with the state machinery. This is the reason.
I'll just close one added thought. I mean, to leave, just to close on a slightly unsettling note. As an agency, the ED has a staggering stat of its conviction rate being in less than single digits. Not single digits, yeah, roughly single digits. So, and bail becomes a norm now, probably a year and a half. So just to put things in context, there'll be a whole host of people who are right now in custody who may end up never being convicted, but spending a couple of years in custody while as pre-trial custody.
But that's what happened in the 2G matter, in the coal block matter, where all this whole things gathered steam. It's very unfortunate, and you're absolutely right. To just confirm the numbers, we have the largest assets in terms of numbers, 1,50,000 crores which are attached by ED. And 1% conviction out of in the 5,500 cases so far filed, which is actually disturbing.